All right, well, I'm Chase McDonald. I am the regional engineer of the Utah Lake Jordan River region, and I'll be talking to you about the application process, approval criteria, and hearings. And to start, there's going to be a short video that was prepared by Teresa, the state engineer.
This video is part one of a three-part video series describing the administrative process that is followed for water rights applications. This multi-step flowchart you are seeing was created many years ago to visually diagram the process from filing to certification. We will use this chart in the video series to describe the administrative steps that are completed once a water right application is filed. Part one of this video series covers the application process from filing to decision of the state engineer, which is shown in the first portion of the blue section of this chart. Part two of this video series describes what happens to an application after the decision is rendered and the administrative remedies parties may seek if they disagree with the decision. This is shown in the second part of the blue section of this chart. Part 3 of the video series covers the administrative process once an application is approved with established time limits and the applicant works to complete the proposed project and fully place the water to beneficial use. Now let's take a close look at the beginning of the process from filing the application to a decision by the state engineer. As authorized under Utah Code Title 73, Chapter 3, an application to appropriate, permanent change, or exchange application can be filed. The application can be received by either our main Salt Lake office or one of the 7 regional offices across the state. If the received application is determined to be acceptably complete with the appropriate application fee, it is filed and the information becomes available on the division's website and a master file jacket is created. If the received application is not acceptably complete, it will be returned to the applicant with an explanation of the deficiencies. Determining that an application is acceptably complete does not mean that the information it contains is correct. It only means the required information has been supplied for an application to be filed. The master files for all applications are stored and maintained in our main office in Salt Lake City. The application review process begins in the regional office that has oversight of the geographical area where the application is proposing to divert and use water. Once an initial review of the filed application is made, the regional office staff will then designate the application for advertising in a newspaper of general circulation in the county in which the source of supply is located and where the water is to be used. In some instances, applications may need to be published in more than one paper. I should point out here the importance that the applicant ensure the application they are filing is correct. If there are errors or corrections made after the publication, the application may need to be re-advertised. This will cause a delay in the process. Applications are advertised for 2 successive weeks. Administrative Rule R655-6 designate adjudicative proceedings of the Division of Water Rights as informal. Therefore, any person interested may file a protest within 20 days after the notice of the application is published. After the publication is completed, a proof of publication is sent by the newspaper to the division to confirm the publication did occur as required. There are limited circumstances defined in Utah Code that may not require the publication of an application. An application for a small amount of water, which is defined as 1 domestic, quarter acre of irrigation, and 10 equivalent livestock, is at the discretion of the state engineer. These types of applications may not be advertised. However, notice of these applications will need to be given if the proposed application for a small amount of water may impair existing rights. Temporary change applications are another type of application that notice is not required. However, in the case of a temporary change, if there is reason to believe it will impair an existing water right, it will be denied. After the application is advertised, the protest period has ended, and the proof of publication has been received, the regional engineer will make a preliminary review of the application and all documents and information. This preliminary review would include a policy review, potentially an initial field review, and data collection. If the regional engineer determines there are now additional parties, protestants, to the application, and there isn't sufficient information to determine if there is reason to believe the application meets the statutory criteria within Utah Code Title 73, Chapter 3, that is applicable to the type of application they are reviewing, an informal administrative hearing will be scheduled. Administrative Rule R655-6 gives authority and defines administrative adjudicative proceedings of the Division of Water Rights. The administrative hearing is scheduled with the Assistant State Engineer for Applications and Records and the Regional Engineer. At least 10 days' notice is given to all parties. Most hearings are held in the county where the water source is located or the county where the majority of the parties reside. Hearings may be held outside the county at the discretion of the state engineer. After the hearing, or if no hearing is needed, the regional engineer will then complete a full review of the proposed application and all associated data to determine if there is a reason to believe the application meets the statutory criteria to be approved. This full review may include a field investigation, review of the appropriation policy for the area, review of scientific data, and a full file review, including title of record with the Division of Water Rights, the protestants' concerns, and any additional information received before, during, or after the informal administrative hearing. Based on the regional engineer's findings, a recommendation is prepared and reviewed with the application and records section. A final draft decision is then prepared for review of the state engineer. The state engineer then reviews the decision, consults with the regional engineer and assistant state engineer. The state engineer will then render a decision to approve with conditions, or reject the application. The decision of the state engineer is served on all parties to the action. Part 2 and Part 3 of this video series will discuss the administrative procedures following a decision of the state engineer.
All right. We have a question, Jim?
Some companies or places I've heard dispute. I think that's the right word, right? When you put in a change application and they say, "Wait, no, we disapprove." It's called disputing, right?
It's a protest.
Or a protest. Thank you. So some people protest every change application in their areas. How is that looked at on the, I guess, on the state level or at your level?
So we'll get to that. That's kind of what this whole presentation's about. But basically, this presentation is all about approval criteria and hearings. And so every application, whether it's protested or not, goes through the same, or has the same criteria for approval that we look at before we issue a decision. But we'll go through that a little bit more. So all the applications that come through our office, there are in statute, Title 73, Chapter 3, there are approval criteria that the state engineer has to look into and address before making a decision. And each of these listed up here, as you see, like applications to appropriate fall under Section 8, change applications, Section 3, and so forth. And so that video went through the first part of this application process. I just wanted to touch on a couple things real quick. First, that 2 weeks of advertising and then a 20-day protest period. Just because an application is protested doesn't mean that it's automatically denied or that it won't be approved. It just means that we need to consider what's in the protest, how it fits into the approval criteria, and if it's filed timely, that protestant becomes a party to the application. And then just touching on hearings real quick, and we'll talk more about them throughout this presentation, but it's important to know that hearings are an informal proceeding, which means that you don't have to have an attorney present. They're really just meant to gather more information. we do frequently see attorneys in those hearings to represent either applicants or protestants, but they're not required, and they don't necessarily give an advantage if they're used. So moving on to approval criteria for each of these types of applications. The standard by which a state engineer evaluates applications is a reason to believe standard, which places a pretty low burden on the party seeking approval. So the lowest standard is reasonable suspicion. The highest is beyond a reasonable doubt. One of the kind of funny things I thought about when I was preparing this presentation is, I recently got engaged and thinking about these different levels of these different standards. I was like, okay, how can I kind of convey these? And I thought, for my fiance to get mad at me, she really just needs that low bar, that reasonable suspicion. But for me to talk her out of being mad at me, I got to prove it beyond a reasonable doubt. So the reason to believe standard is just one above that reasonable suspicion. And I can't wait to tell her that joke to give her more reasonable suspicion. But moving on from there, so the first criteria only applies to applications to appropriate, and it's just that there's unappropriated water in the source, in the proposed source. You may ask yourself, how do I know if there's unappropriated water? So this map is available on our website. The red areas indicate areas that are closed to new appropriations, and going off of the question that was asked in the previous presentation, that doesn't necessarily mean it's closed to diligence claims, it's just closed to new appropriations. The yellow indicates areas that, what word did they use? Restricted, which typically means it's only open to small domestic applications. And the green areas are open for new appropriations. The little blue circles in there indicate areas with implemented groundwater management plans. But for applications to appropriate, there has to be unappropriated water in the proposed source, and you can use this map to help you navigate that. The second is that the proposed use will not impair existing rights or interfere with beneficial use of water. And when we talk about quantity impairment, I'm not going to touch on it too much or delve into it too much because there's an entire presentation tomorrow that's just talking through quantity impairment versus the rebuttable presumption of quantity impairment. But what's important to know is that is one of our approval criteria is that there's reason to believe that the change or the application will not impair existing rights. There's another little piece in there that says the change does not impair an existing right without just compensation or adequate mitigation. The other side of quantity impairment is rebuttable presumption of quantity impairment. And I'm just mentioning those here. Like I said, there will be an entire presentation on those tomorrow. But one of the important things to know when it comes to approval criteria is that if quantity impairment or rebuttable presumption of quantity impairment is raised, it's the applicant's burden to overcome that and to produce evidence for a reasonable belief that other rights won't be impaired. And when it comes to rebuttable presumption of quantity impairment, statute directly says the state engineer shall reject a permanent change application if the person proposing to make the change is unable to meet the burden described in that subsection, which that subsection talks about rebuttable presumption of quantity impairment. So still sticking with the theme of impairing existing rights, just wanted to touch on temporary change applications real quick. So temporary change applications are not advertised. We don't hold hearings on them. And from the date of approval, they expire after 1 year. Statute is pretty clear on these as well. If there's reason to believe that the application could impair existing rights, it will be denied. If there's not, it'll be approved. And in cases where there's reason to believe that it may impair or will impair another water right, a permanent change application is a better way to go because it goes through the public process and we can, it goes through a protest period. We can hold hearings and do a little more digging into that application to make the right decision. If you're unsure of whether a temporary or permanent change application is more appropriate, feel free to reach out to the regional engineer or the regional office that the project, or for the region that the project is in, and we can help you determine what might be best. Yep, we got a question.
Can temporary change applications be filed for more than 1 year?
For more than 1 year, no. So depends how you mean that. If they can be filed year after year, but they still expire, we see it quite frequently that somebody will file one, and then before it expires, they'll file another one that's basically the same thing. We do have fixed time change applications that can be approved from anywhere from 1 to 10 years. So that's kind of the buffer in between a temporary and a permanent. So moving on to talk about exchange applications, there's a little bit different approval criteria for exchange applications, or I should say some additional. Exchange applications are if you have water approved out of one source and you want to exchange that for another source within the same drainage, you may be able to file an exchange application. Most of these are filed in our Weber River drainage, but the additional criteria there is that the original water must not be deteriorated in quality or diminished in quantity. Whoever's filing the exchange needs to have a legal interest in the underlying water right. These are usually accomplished with contracts with water right owners. So
I asked somebody else to ask, and they said no, I had to ask. Is this the same thing as going from the groundwater to the underground water? Or surface to underground water?
No, that's a question of, the source, the point of diversion. There can be exchanges that are filed from surface to underground, but that's not unique to exchanges. You can have change applications proposing to move from a surface source to an underground source. So an exchange, and I rarely see these in my region. I rarely have worked on them myself, so I may not be the best person to ask, but Blake's gonna.
Yeah, we'll just give you a quick example. So in the Weber Basin, there's lots of exchanges, right? Where Weber Basin Water Conservancy District owns the water in Pineview Reservoir and these other reservoirs. Someone will file an exchange asking Weber Basin to release that water to downstream users to keep them whole, and then they will drill a well. And so they are going to exchange the water that they are diverting out of their well for the water that Weber Basin will then release to make sure that downstream users are not impaired. So that's the most common type of exchange. There are other types, but I think, as Chase mentioned, that's the most common.
Okay, thank you, Blake. So moving on to the third approval criteria discussed in Section 8 is that the proposed plan is physically and economically feasible. And again, it's a fairly low burden reason to believe, so it's not like we're going to ask for, the final design, super in-depth set of documents to overcome this, but just that it's reasonably probable that it's physically and economically feasible. And that kind of goes a little bit hand in hand with the next one, that the applicant has the financial ability to complete the proposed works. And one thing about this one can kind of be dependent, the requirements for this can be a little bit dependent on the project. If you're just proposing to build a house, it's probably a lower burden than if you're proposing to, build a nuclear power plant on the Green River. So just keep that in mind. But I'm going to go back one. Discussing financial ability, physical and economical feasibility. There's section 73-3-11 talks about some of the things that the state engineer may require or may ask about when evaluating this, and that could be articles of incorporation, information about directors and officers, or maybe some financial information. That's you can read 73-3-11 for that if you're curious. Yeah, we have another question.
Does the division look at the health of where the well would be drilled if it was, say, in an abandoned gas station and somebody applied for a well? Or
You're just talking about water quality?
yeah, who's the oversight of who says where that, or can a well driller just go drill wherever they want as long as it's on the property that was
So my answer to that, we do have some areas that we're aware of that there's groundwater contamination, and we have some restrictions on those particular areas, and you can find those on our policy pages or various places on our website, or you can contact us for those. But in terms of just, hey, there was a gas station here, I'm not sure that that's something we typically look into. But I'm guessing, some of the local health departments or somebody may have questions about construction of things like that. Division of Drinking Water, yeah. Yeah, thank you. Okay, so the next statutory, or the next piece of approval criteria is that the application was filed in good faith and not for purposes of speculation or monopoly. And we all know how important water is in Utah. It's a public good, and a water right just gives you the right to use that water. So this is meant to kind of protect all of us from somebody buying up a whole bunch of water rights and just holding on to them, jacking up the prices so they can sell them. And we actually have had at least one case with this. Back in 2008, there was an application filed that really didn't mention much about beneficial use other than a plan to sell that water to others. And it was found that the applicants had no lands, facilities, customers, or contracts. And so that's a good example of an application that would not meet that criteria. And then Eric said that he guaranteed somebody would talk about groundwater management plans. This is about all I'm going to talk about with it. One of the criteria for approval is that, if applicable, if it's in an area where there is an implemented groundwater management plan, the application has to fit the guidelines of that plan. And again, I'll talk about it in a few slides here, but there's a policy page on our website where you can go to find if the area you're working in has any implemented groundwater management plans. Also in 73-3-8, the statute talks about if the state engineer does have reason to believe that an application will interfere with water's more beneficial use, will unreasonably affect public recreation, or will prove detrimental to the public welfare, the state engineer, and it doesn't say can, it says shall withhold approval or rejection of the application until it can be further investigated. So that's in a nutshell, the approval criteria. We'll move on and talk about hearings now for a little bit. As we've discussed, applications are advertised for 2 weeks, and then there's a 20-day protest period. And then it's at the discretion of the regional engineer whether a hearing will be held or not. And really, the purpose of these hearings, again, they're informal proceedings. You don't need an attorney to be there. The applicants and protestants or whoever else the parties involved can represent themselves, but it's really just to gather additional information so we can make the best decision on that application. So again, the parties to the application are applicants, protestants, and the state engineer. And those are protestants that filed a timely protest. These hearings, they may be held if requested in a timely protest. They may be held if a regional engineer decides to hold a hearing and there wasn't even a protest. We can still hold a hearing. Typically in those cases, though, if there's not a protest, we'll just reach out to the applicant, and gather whatever information we need. Again, it's an informal proceeding. Attorneys are not required to be involved in that. These hearings are open to all parties, and it's just to introduce evidence, make arguments, ask questions. The hearings do have a structure to them, but it's in essence almost an open forum to discuss and ask questions and gather more information about the applications. Non-party participation at hearings. So this would be attorneys, engineers, geologists, hydrologists. They can absolutely act as a witness or be there as representation for applicants or protestants. It's not required, but it's important to remember that the parties to the application are the applicants, the protestants, and the state engineer. Non-party participants may not seek judicial review, and we'll talk about that more in a little bit. So if after a decision is issued, there are aggrieved parties, or somebody doesn't like the decision, one of the parties can request reconsideration of the application or judicial review. And I have another video by Teresa that will go over that a little bit more, that whole process. But again, the purpose of these hearings is just to gather additional information, and the bullets below that, those are all of our approval criteria for these applications. So it's very black and white. We present it to you so that if you're an applicant or a protestant, you know where to go to look for these. You kind of have an idea of what they mean, and you can fit your application or your protest or your response to protest. You can fit them into the statutory criteria. A lot of people bring up information that is not really within the state engineer's powers or purview. They'll say, we don't think this fits within zoning or something like that, and that's not part of our criteria to evaluate these applications. So let's talk a little bit about division policy. I think you've seen this map already, but this is on our website. The colors indicate the different regional offices, and you can click into, it's an interactive map on our website. You can click into any of those areas and see the state engineer's policies in those areas. And you're always welcome to call the regional office or the regional engineer, and if you have any questions about the policies or any groundwater management plans in the area, you're always welcome to call us for clarification. This next, not every area has specific policies or management plans. Here's just a list. They are statewide. Not everywhere has them, but they are all across the state. There's the Salt Lake Valley Groundwater Management Plan, Colorado River Policy. There's one down in Sevier. Down in the southwest, there's the Milford and Black Rock policies. Weber, Willow Basin, those are all on our website. There's a summary page. If you go to that policy map and click one, there's kind of a summary of it, or you can click in and see the actual published implemented plans. So when the state engineer reviews or makes a decision on these applications, the outcome is either going to be an approval with conditions, or a rejection. An approval and a rejection, pretty self-explanatory. But what are these conditions? Pretty much, in fact, I'd say every single change application that gets approved will have some conditions, and we'll kind of go through some of those. Diversion, depletion, reduction, like Eric said, the limit of a water right, or the definition of a water right, is its beneficial use. Whenever we evaluate these applications, we will quantify them, and we'll put in the conditions, we'll put the volume or flow rate or whatever else, the limits of the water right. And it could be diversion and it could be depletion. We can place in condition that requires the applicant to meter, measure, and or report. Pretty much every application in my region requires, and I think it's statewide, requires the installation of measuring devices. Not all of them require reporting. But for municipal or in certain areas, if an application proposes a large enough water use, we can require annual reporting to our water use program. Well abandonment. If an application moves either all of the water or the last bit of water that was approved out of a well into a different source, we require that well be abandoned to protect the resource from contamination and some other things. Retiring prior use, again, with change applications, any approval of a change application, if you're going to try to move water from one place to the other, and then in order to accommodate that, historical use needs to cease. Otherwise, we're just doubling up water. Maintaining shares, we see a lot of applications filed that are not, well, they're based on shares in an irrigation company. And when those are approved, the applicant is required to maintain those shares in good standing with the company. And if an applicant owns shares and they stop paying their assessments or whatever the case may be, the irrigation company can petition the state engineer to reverse the approval. And we've done that in some cases. And then, I talked about kind of what the state engineer can do, what the state engineer can't do. One thing that the state engineer cannot do is, even if we approve, or if the state engineer approves an application to divert water out of a well, if the applicant doesn't have legal access to that well, the state engineer can't grant that access. So sometimes we put that condition on there, just reminding people, whether that condition's in there or not, it's still the legal reality, but sometimes we put that in there just to remind everybody. Okay, for municipal rights, a lot of times we see a municipality will contract with a water user to purchase their water, and they'll file a change application before that purchase actually takes place, and so the water right is approved for municipal use but is not in the name of the municipality. In those cases, we'll place a condition that title of the water right needs to be in the name of the municipality before we'll issue a certificate of beneficial use. And then in some areas of the state, we have distribution systems, and we have, like on the Provo River, we have the Provo River Commissioner, and a lot of the applications in those areas will put some kind of condition that it's the Provo River Commissioner's call to distribute that water, and so we can put conditions on that as well. And it's, with these conditions, part of the reason I bring it up is it's important when, I think, and I could be wrong, but I think a lot of times when somebody receives an order of the state engineer and they read through it, they get down to approved, and they, cheer, whatever, and that's all they read. They don't read the rest of it. But these conditions are highly important, so make sure that you read and understand those. So again, 73-3-8 says it shall be the duty of the state engineer to approve an application if there's reason to believe that all those conditions are met. Then it's approved. We can place conditions on those. Otherwise, the application will be rejected. And then, that's not necessarily the end of the story. There is a process for submitting a request for reconsideration or going through the courts and, seeking relief through the courts. And that's where Teresa is going to pick back up with this other video to talk through that process.
This video is part 2 of a 3-part video series describing the administrative process that is followed for water right applications. This multi-step flowchart you are seeing was created many years ago to visually diagram the process from filing to certification. We will use this chart in the video series to describe the administrative steps that are completed once a water right application is filed. Part 1 of this video series covers the application process from filing to decision of the state engineer, which is shown in the first portion of the blue section of this chart. Part 2 of this video series describes what happens to an application after the decision is rendered and the administrative remedies parties may seek if they believe they are aggrieved by the decision. This is shown in the second portion of the blue section of this chart. Part 3 of this video series covers the administrative process once an application is approved with established time limits and the applicant works to complete the proposed project and fully place the water to beneficial use. The water right application process shown is authorized under Utah Code Title 73, Chapter 3 for appropriation of water. This flowchart process is applicable to applications to appropriate, permanent change applications, and exchange applications. There are other authorized types of applications that follow similar administrative steps or portions of these steps. However, this video is intended to focus on the administrative process for these 3 most common water right applications. For part 2 of this video series, let's now take a close look at what happens once a decision is issued by the state engineer and the administrative remedies a party has if they believe they are aggrieved by the decision. Once a decision is issued on a water right application, that decision may approve an application, reject an application, or approve an application with conditions that must be met by the applicant as they proceed with their proposed project. The decision is served on all parties to the application. All parties include the applicant and all the protestants to the application, and of course the state engineer. The decision is issued as an order of the state engineer. If the parties accept the approval of the application, including any required conditions, the applicant can then work to develop the proposed project to place the water to full beneficial use. As part of the conditions under which an application is approved, the state engineer will set a time in which the applicant shall construct the works, apply the water to beneficial use, and file proof with the state engineer. The time limit given is generally 5 years from approval of the project. For larger projects, additional time may be allowed. Part 3 of this video series will cover completing and proving the project is complete. If the state engineer does not have reason to believe the application meets the statutory criteria within Utah Code Title 73, Chapter 3 for approval, the application shall be rejected. If the parties accept the rejection of the application ceases. In some cases, a party to the application may believe they are aggrieved by the order of the state engineer. The order of the state engineer is subject to provisions of Administrative Rule R655-6 of the Utah Division of Water Rights and to sections of Title 63G, Chapter 4 of the Utah Administrative Procedures Act and Utah Code Section 73-314, which provide for filing either a request for reconsideration with the state engineer or for judicial review with the appropriate district court. A request for reconsideration must be filed in writing with the state engineer within 20 days from the date of the order. The written request shall be filed in person, by mail, or electronically. If the request is filed electronically, it shall be submitted to the authorized general email for the division, which is waterrights@utah.gov. When a reconsideration request is received, the division will send notice of the request to all parties and may, within 20 days from receipt of the request, deny or approve the request in part or in whole, issue an order, or rehear the application. If the state engineer does not issue an order within 20 days from the date of the request for reconsideration, the request shall be considered denied. A request for reconsideration is not a prerequisite for filing a judicial review. If the reconsideration request is granted, all parties to the decision are notified. Granting of a request for reconsideration sets aside the administrative decision on the application in its entirety, and the status of the application reverts back to the status prior to the order of the state engineer. The regional engineer then reviews any additional information and conducts further investigations to determine if there is reason to believe the application meets the statutory criteria for approval. Another informal administrative hearing may be scheduled. The result of this investigation and new determination is an amended order of the state engineer. The amended order is again served on all parties. If the parties accept the amended order approving the application, including any required conditions, the applicant can then work to develop the proposed project to place the water to full beneficial use. As with the original order, the state engineer will set a time in which the applicant shall construct the works, apply the water to beneficial use, and file proof with the state engineer. Part 3 of this video series will cover completing and proving the project is complete. If the state engineer does not have reason to believe the application meets the statutory criteria within Utah Code, Title 73, Chapter 3 for approval, the application shall be rejected in an amended order of the state engineer. If the parties accept the rejection of the application ceases. If a party still believes they may be aggrieved by the amended order of the state engineer, as with the original order, the order of the state engineer is subject to provisions of Administrative Rule R655-6 of the Utah Division of Water Rights and to sections of Title 63G, Chapter 4 of the Utah Administrative Procedures Act and Utah Code Section 73-3-14, which provide for filing either a request for reconsideration with the state engineer or for judicial review with the appropriate district court. The result of a judicial review will be a decision by the court. The decision may be consistent with the order of the state engineer, or it may reverse the state engineer's decision. If the court's decision approves the application, the applicant may proceed with developing the project. If the order of the court rejects the application will cease. A party may file for an appeal of the district court's decision with the Utah Supreme Court. Now let's look at the remedies if reconsideration was not granted. A party may, within 30 days, file for judicial review with the appropriate district court. Again, the result of a judicial review will be a decision by the court. The decision may be consistent with the order of the state engineer, or it may reverse the state engineer's decision. If the court's decision approves the application, the applicant may proceed with developing the project. If the order by the court rejects the application will cease. A party may file for an appeal of the district court's decision with the Utah Supreme Court. If the original order approved or approved with conditions and the reconsideration was not granted and no judicial review was filed, the parties accept the decision. The applicant shall then complete the project as approved and fully place the water to beneficial use within the time limit established in the order of the state engineer. Part 3 of this video series will cover completing and proving the project is complete. If the original order of the state engineer rejected the application, the reconsideration was not granted, and no judicial review was filed, the parties accept that decision and the application ceases. Orders of the state engineer approving an application will include a time limit in which the applicant shall complete the project and place the water to full beneficial use. Part 3 of this video series will discuss the administrative procedures following the approval of an application.
Okay, so that concludes my presentation, pending any questions. Okay, so the question is, can the state engineer appeal decision that was in the court? Yes. Blake's nodding yes. I have no idea. Blake's nodding yes. Okay. Any others? Okay. Cool.